But before I get into the housekeeping, I want to introduce our hosts for today's webinar. It is Courtney and Kevin from GRS. And Courtney, I'm going to kick it over to you to tell a little bit about yourselves and your organization. Courtney.
Thank you so much, Jeff. Hi, my name is Courtney Buchan. I'm the corporate trainer for GRS Community Management. I'm joined here today with Kevin Quinn, our Chief Operating Officer. We've been in business providing great, reliable service since 1989. We're a mid-sized management company located in Lake Worth, and we manage over 300 associations. Today, we're going to be providing a course, conflicts of interest, what you need to know. I just want to take a minute to thank Jeff and everyone at Kaye Rembaum for providing this course for us today. I hope that we have many of our GRS association managers join today, hopefully some boards. We're going to be doing more of these in the future, specifically with Kaye Rembaum, so be on the lookout for that. So today's speaker is Allison Hertz. She is an attorney with Kaye Rembaum. She is going to be going over the course, conflicts of interest, what you need to know. Some of the things that she's going to be going over is identifying conflicts of interest, any new statutory requirements, how to document disclosures, training staff, and internal controls. So without further ado, Allison, take it away.
Thank you, Courtney. Thank you, Kevin. Happy to be here today. I'm Allison Hertz. I'm an attorney with Kaye Rembaum. I'm in the firm's Palm Beach Gardens office, and obviously I represent associations all day, every day. This is what I do in life, and here to talk about conflicts of interest and related issues. I'm very involved with the condo and HOA law. I serve as the co-chair of the Florida Bar's Condominium and Plan Development Committee, and deal with the legislation that we see probably year after year. It's barely go a year without seeing some new statutory amendments for our condo HOA clients. So we will talk about a few of those new laws as we go through the program today. They specifically relate to HOA communities, just to give you a quick heads up about that. I'm going to share the screen now. We have a PowerPoint. And as Jeff mentioned, I would love to take questions as we go, but I tend to talk a lot. And so I probably will have a hard time getting through the course if we take questions as we go. So if we have time at the end, we will take questions, and I have a feeling people will have the same question somewhat over and over again on these topics, because we all hear frequent questions related to conflict type issues. So we'll see if we can get to those at the end. So your presentation, and then go ahead and submit the question towards the end. So, all right, let me get my screen share. I am not an expert tech person, so give me a second. Okay. Are we seeing the right screen?
Yes.
Okay.
Yes, perfect.
All right, thank you. All right, so before we get started on the meat and potatoes of this presentation, I wanted to share some quick stats just to put some of this stuff in perspective for the audience, where we have a lot of community associations out there. It's very rare these days where you can even find housing not in a community association, plan development type community. And in Florida, we've now fallen actually to number 2. But we have 48,500 associations, condo, HOA, and co-op associations. So we're right there behind California, but above Texas. So number 2 in the entire country of associations. We have about 58 to 60% of those being HOA associations, 35 to 40 being condo, and 2 to 4 being co-op associations. I'd be shocked if anyone even on the call isn't a co-op association, but we do have some beach condos. A lot of the time, that's who we see as the co-ops. So this is huge here in Florida. This is, everyone out there, most oftentimes either you're in an HOA, you know somebody in an HOA, your family's in an HOA or condo. So this is pertinent to so many people out there in the state of Florida, particularly, and then a lot of the other states as well. So here today, I feel like we probably have a lot of board members and managers on the webinar, but when you're a board member, you're an officer or director of a corporation. I think people forget about that sometimes, that these associations, they're corporations, they're not-for-profit corporations, and they're incorporated under the Chapter 617 of the Florida statute, the Florida Not-for-Profit Corporate Act. Don't be confused that they're non-profit associations for charitable purposes that don't pay taxes. That's not what associations typically are. We're considered a not-for-profit corporation, and you are an officer or director running this business, and this is serious business a lot of the time. There are nice parts of the job, right? But a lot of times you're dealing with pretty serious issues, financial issues, business matters, contract matters. So just remember, you're an officer or director of a corporation. If that was your dream in life, now you are there. But let's talk about this and get this off the table really quickly into the course. For being that officer or director of this corporation in Florida, do you receive a salary or compensation for the job? You know, you're a highly compensated executive, maybe in your real life hat, but do you get to be compensated for your service to your association? Most oftentimes, no, that is not going to be the case. So let's re-review the law here concerning condominiums. For a condominium director, unless provided otherwise in the bylaws, the members of the board shall serve without compensation. That's also the officers of the association. So unless your bylaws have been amended with likely a unit owner vote there, you do not get compensation for your service as a director or officer to your condominium association. Similarly, an officer, director, and committee member of a homeowners association cannot receive a salary or compensation from the association for their performance of their general duties to the association, with some exceptions. You can get reimbursement for out-of-pocket expenses, and we'll talk about that a little bit when we talk more about internal controls down at the later part of the presentation. You can have a fee or compensation authorized in the governing documents. Once again, if your governing documents allow for this, yeah, okay. Or any fee or compensation authorized in advance by a vote of a majority of the voting interests, voting in person or by proxy at a meeting. So there are ways to be paid for your service as a director, but as we all know, it's very unlikely, and you cannot do so without the proper authority here. Sometimes you might see, if you're in a very large HOA community where you essentially have professional board members who are paid and they're allowed to be paid pursuant to the bylaws, okay, but you know, sorry, you're running this Florida corporation and you really can't be paid most of the time. Although you cannot be paid, you do have great responsibility as a officer or director of an association. You are required to act in the best interest of the association and the unit or lot owners. And this is generally what's known as your fiduciary duty, your fiduciary relationship to the lot owners and the unit owners, and where you have to act in the best interest and not in your own personal interest or financial interest. That's where we start to see the trouble brewing. So I like to go over this just to remind everybody what their duties are as an officer or director, and somewhat, I hope, in some ways put everybody's mind at ease, where, you know, most oftentimes you're going to be protected as the director or officer. It's only really when you start going into these bad acts where you might not be protected. So, and that's generally few and far between. So what are your duties as a director? Your duties are to discharge your actions in good faith, with the care of an ordinarily prudent person in a like position would under similar circumstances, and in a manner you reasonably believe to be in the best interest of the association. To break down what your fiduciary duty. That's the description in the statute. But you're not alone. You are with a group of people, you have a team, you generally have management and professionals to help you along the way. So in discharging your duties, you are allowed to rely on the information, opinions, reports, financial statements, and other data prepared by others. This could be other officers of the association, committees, legal counsel, your accountants, or other persons who you believe are experts in the field, engineers, architects. So you have professionals that you can rely on and base your decision-making accordingly. What is a problem is that if you are a director, and for example, you are an engineer, you are a lawyer, you are a property manager, or you have some specialized knowledge that makes your reliance on those others unwarranted, like you know better, then you're not acting in good faith, right? So you can't just divert to somebody else to tell you something that you know is wrong. That is not going to be a good idea there. But a director, once again, is going to be generally protected from decision making. And you know what? You can make bad decisions. You're somewhat are allowed to be negligent as a board member because you're not a professional. You're running a not-for-profit corporation, but you are going to be liable if you breach any one of these things, right? So if you had knowledge of something that made your reliance unwarranted, that's a problem. But otherwise, it's the statute specifically says the director is not liable for any action taken as a director or any failure to take action if they performed the duties in compliance with this section of the law. What about community association managers, management companies? There are specific statutes that govern managers and management companies, and they do provide for some similar duties. A manager has to discharge duties loyally, skillfully, and diligently, dealing honestly and fairly and in good faith, with care and full disclosure to the community association, and not charging unreasonable or excessive fees. So that's a general professional standard for managers. Also interesting, as we have a statutory provision where an association is generally going to be responsible for what a manager or management company does to the extent that it's not, a real problem. But the statute specifically says, the law specifically says an association cannot be responsible for a manager that acts grossly negligent, reckless, in bad faith, with a malicious purpose, or in a manner exhibiting wanton and willful disregard of human rights, safety, or property. So despite the fact that, you have a contract with a manager, a management company generally, that says you have to sort of defend them and indemnify them for what they do in their ordinary course, if it rises to this level, then that's not part of your responsibility. Okay, so, sometimes, for the most part, in my practice, which is going on, I don't know, a long time now, actually, we have board members who are great on the up and up, and the vast majority of people are good people and do this to volunteer for their community, as you all probably do, and just want to do the right thing, want to make sure there's not waste of expenditures, want to protect the community, enhance the community, beautify the community, possibly change the rules in some ways, and that's not bad. That's not necessarily a bad thing, but you can't be acting, you can't violate the law in your capacity as a board member. And we do have some very specific laws on this, and when you can be liable in your capacity as a director. Here, you can be liable if you violate the criminal law, or this is number 2, seems to come up the most frequently. If you perform an act where you're deriving an improper personal benefit, directly or indirectly, or number 3, if you act recklessly with bad faith or malicious purpose, or in a manner exhibiting wanton and willful disregard for human rights, safety, or property. So this is where you could, have some possible personal liability as a board member. These are sort of the bad acts that I talk about where you will not be protected by the law or possibly by your directors and officers insurance policy. And this is where you need to be mindful of what you're doing as a director. And typically speaking, it comes to number 2, where we see where there's something kind of like on the edge of where it could be an improper personal benefit or not. One of the things I'll just stop and talk about with respect to this slide is, I always hear about, realtors on the board, and I feel like we'd probably get a question from the audience on realtors on the board. And that's not necessarily a conflict of interest issue. A conflict of interest is where you have a board member actually contracting with the association, entering into an agreement with the association, giving services to the association. For a realtor on the board, you have somebody that might have inside knowledge or the ability to approve or disapprove their own contract. You have a screening authority as an association, and you have to approve sales and leases. You have a board member who is a realtor with a deal that comes across the table. This is something where I feel like it could sometimes get on the edge of an improper personal benefit, right? So if you are a director and one of your contracts is up for approval, you're the realtor, this is one where you might want to step aside from that decision to approve or reject the transaction, because it could be asserted that your influence in that decision is some kind of improper personal benefit. There is no case on this. There is no specific thing that I can reference concerning this issue, but this comes up all the time where we have, it's a very frequent question that we get where, can realtors be on the board? Yeah, of course they can be on the board. That's fine. Can they approve other contracts? Yeah, probably. Unless they are acting in a way that gives them an improper personal benefit by the way that they're handling the transaction. So this is something that you got to really see the facts, but I just wanted to distinguish this from a conflict of interest issue. Jeff, were you going to jump in here?
What if it's, because this question comes up a lot too, maybe we can prevent some of it. What if it's a homeowner, somebody who lives in the association, not on the board, who owns and I'm making this up, owns a roofing company? Is it a conflict if that homeowner's company gets the job to replace roofs and common elements?
Well, you're skipping ahead, Jeff, but that's okay.
All right.
That usually is not a problem. It's not a violation of the law, except for in one instance in a condominium association, which there's a specific slide later in the program. It's just might not be a great idea, right? I mean, it's not violating any law, but when you're getting into a contract with a resident and then you have a problem with the contract and a fallout possibly, how is that all going to go down? It just is one of those things. Maybe it could be very helpful because they're always there. They're going to be responsive. It's their community. They want to put the effort into it. But on the other hand, when things go south, that's where I see it being a problem, right? Okay, so getting back on gear here, more criminal activity type issues. The law says that an officer or director charged with theft or embezzlement, forgery, refusal to allow access to official records, and furtherance of a crime is going to be in trouble, is going to be subject to criminal laws, criminal actions, I guess you would say, charges. I'm not a criminal lawyer, but if one of these charges is pending against the officer or director, they're not allowed to be appointed or elected to the board. They're not allowed to have access to official records of the association, except pursuant to a court order. If they're found innocent after all these charges are resolved without a finding of guilt, they can be reinstated on the board. And it's kind of sad that we have to even talk about this, but this does happen. Everybody knows about the hammock situation down south, where there were allegations of theft, embezzlement, and charges brought, I understand. So this is really, out there in the news all the time lately, and just know it's there. The HOA law was just amended to incorporate some of the provisions that were always there for condo. So now these two bullet points are essentially the same for both condos and HOAs, HOA being effective in a couple months now. Okay, so I'm sure everyone's like, oh my God, I'm really stressed out about this, Allison. You've just told us all these things that we need to do and obligations and duties and personal liability. And I'm just getting really stressed. I don't even know if I want to do this anymore. Well, I hope that's really not the case, because I did preface everything by saying that you are well protected as a board member. You're allowed to make mistakes. You have directors and officers insurance. I hope you do. I mean, that's something that I'm sure GRS and other management companies ensure that you have, because you need to have that. We'll talk about that if we have time later. But you know, one of the best things that you can do to sort of ease your mind regarding these duties, obligations, statutes is to be learning about condo HOA law. That is why you're here today, to learn about these things, and that you attend board certification courses. Everyone probably knows that within 90 days after being elected or appointed to the board, you either have to attend an educational course or sign a certificate that you will uphold all the governing documents and act appropriately. But I would really urge everyone to attend the course. We give them all the time. Other firms give them all the time. Of course, ours are better, but management companies give them. So you should take our course, and then also take as many courses as you can fit into your schedule. Unfortunately, the law provides that you only have to do the course one time if you continue to serve. So if you serve every year without a break, you really only have to take the course or sign the certificate one time. But I do urge you to take this course probably yearly, because the laws change so much. And the board certification course gets into like the basics of board meetings, membership meetings, official records access, enforcement issues, budgeting. So these are things that will really enhance your ability to function as a board member or manager, really, and give you more confidence in terms of your abilities to not get in trouble, right, if you know the law. So let's talk more about improper personal benefits. I mentioned that at the beginning, where this is sort of like the pitfall area that I see most often. And sometimes it's, not even intentional, right? You just don't realize that's what's going on. I gave the example of the realtor situation just because some people always ask me about that. But the specific statute provides that an officer, director, or manager may not solicit, offers to accept anything, service of value, or get a kickback. We all know what that is, for any, where they haven't gave any payment for the item or the service. So you say, okay, well, what does that really mean, Allison? Well, what that really means is you can't, and I mean, I think this is common sense, but it's good to hear this. You can't go out to bid to a landscaper and say, okay, well, we'll give you the bid if you remulch my yard for free. That's completely inappropriate. It's an improper personal benefit for which you could be in breach of fiduciary duty. And if you do that, or you allow your family members to do that, you could be subject to civil penalties as a condominium board member, or now in the HOA realm, the statute was amended to also provide for these civil penalties. So this is where I really see the most trouble. Sometimes you don't even know that you're doing it. Like, for example, a board member will call me, we'll talk about the association matter, and then they'll say, oh, by the way, I have this rental condo in, down south, and I was wondering if you could help me, with this issue. And, you can't really use your position as a board member to try to get free legal advice. That's just kind of like a benign one. You wouldn't even think that you're doing it, but it is, problematic. So you just have to be cognizant of this and just keep it in the back of your mind when you're acting in your capacity as an officer, director, or manager. What this does not prohibit is going to trade shows and educational events where you may get, you know, a ruler or a pad of paper or a plant or a glass of, you know, coffee from an educational trade show. You can pick up those items, you can win a raffle. That is not prohibited by this statute specifically. What about lunch? What about food, right? It's funny because for homeowners associations, the statute specifically addresses this. It provides that you as an officer, director, or manager are permitted to accept food with a value of less than $25 at a business meeting. So I always say this is like the no dessert rule, because what can you really get for less than $25 these days? It's, you know, this law was from, I don't know, I want to say 10 years ago. So maybe that should get bumped up at this point. I don't know. But that's there for homeowners associations. It's not for condominium associations, which is interesting. It's just, you know, sometimes the statutes don't exactly mirror each other, which makes it difficult for everyone, including me and all of you. Okay, so now we're into the real conflicts of interest issues. And these are really interested transactions. That's what I think that they should be called, because that's what they really are. The course title conflict of interest is sort of like a general term, because that's what I guess I would call all of this stuff all together. But what are really conflicts are interested transactions where you have an officer, director, committee, you know, manager contracting with or getting services to the association for payment. So let's talk a little bit like about what this is. You know, is it real? Does it currently exist? May it exist in the future? Or could the members just think it exists? I mean, the realtor thing is a good example of a perceived conflict. That's not really a conflict of interest. They're not giving services to the association for payment. It's, you know, potentially using their position for their own personal benefit, but it's not a conflict. What's also a perceived conflict I hear a lot of the time is that, you know, Jack got on the board because he has a dog and he wants to amend the documents to eliminate the restriction on, you know, this breed of dogs or the number of dogs. And he has an interest in this issue, and therefore, you know, he shouldn't be able to vote on the proposal of this amendment. Well, that's not a conflict. I mean, if you weren't allowed to have a platform or sort of politic for certain things, I don't think we'd really have a lot of board people, because usually, you know, you get on the board with something in mind that you want to do or that you don't want to do, or that you don't want the association to do. So just because you might like something or want something, you know, doesn't necessarily make it a conflict of interest. If you want to lease your house, right? And you're thinking about, there's rental restrictions. You want to do away with the rental restrictions because you want the rental income. I don't necessarily think that's a problem either. You have to propose the amendment. The owners have to vote on it. So those things are just perception issues. I'm not saying that there's no perception problem, because you usually have to explain that and sort of become defensive sometimes. But it's not a technical type of conflict issue. Once we had a statute quite a while ago in the condominium statute here, where it basically said that a board member could not sorry, you had a board member who could not give services to the association. Well, basically it just said, no, you can't do it. Like if I have a landscaping company, I could never have my company service the association. It was just a complete no. But this law was actually repealed in 2021. And so there, you know, the whole interested transaction issue is not a complete no. You just have to jump through the proper hoops and do the proper disclosures, which is the next slide. So if you have, now we're talking about condo specifically. I don't really like to, I try not to say, okay, this is for condo, this is for HOA, but these are, the next few slides are going to be condo, and then we'll do HOA afterwards, just so you're aware of that. because they are slightly different. This is one of these situations where they are slightly different, so which is somewhat annoying. So here in condo, if you have a situation where you as a board member or officer or any of your relatives have an activity that may reasonably be construed to be a conflict of interest, you need to disclose it, right? Before you have the board try to vote on the matter. There are two situations, A and B here, where it's presumed that there is a conflict situation. A director or officer or their relative enters into a contract for goods or services with the association, or the director or officers or their relative's company tries to enter into a contract with the association. So it's either the director or officer or their family member, or one of those persons' companies is trying to contract with the association. If so, they have to disclose that. The conflict issue has to be disclosed on all the documents related to this. We're going to a board meeting to approve a contract with the president's landscaping company. On the notice of the meeting, it should say consideration of interested transaction situation. So all the documents have to disclose that this is an interested transaction. This kind of interested transaction has to be approved by 2/3 of all of the other directors, not including the interested director. This is a key factor that I feel like people miss here. At the next regular or special meeting of the membership, which probably is going to be your annual meeting, you have to then once again disclose this interested transaction. You would have it as an agenda item. You know, we want to announce, if you might have not been at this board meeting on X date where we approved the landscaper, the president's landscape company to be our vendor, you have to disclose it at that membership meeting. And then any member in attendance can bring up a vote to cancel the contract. And that's done at the next membership meeting. And basically at every meeting thereafter, if it's some kind of contract that renews on a yearly basis. So this is what I see people miss a lot of the time. They go through the steps of having it disclosed at the board meeting, 2/3 of the non-interested board members vote for it, but they fail to disclose it at the membership meeting. There's another opportunity to cancel the contract as well. In a condominium association, even after that membership meeting takes place, if you get a petition from 20% of the voting interests of the condominium association to cancel that interested contract, then it's canceled. So there's those two opportunities to cancel the interested contract, one at that membership meeting and then one after the fact based on a petition. Here in the Condominium Act, if you see number 6, I talked about, the interested transaction with the officer, director, or their family member or relative. So in the Condo Act, the relative is defined. It means a relative within the 3rd degree of consanguinity by blood or marriage. And unless you're some estate attorney on this call who happens to be a board member, you likely that you're like, what is the 3rd degree of consanguinity? Well, the 3rd degree of consanguinity are children, parents, brothers, sisters, half brothers, half sisters, grandparents, grandchildren, uncle, aunts, nephews, nieces, great grandparents, and great grandchildren. So this conflict extends quite far. So even if you're a board member and you're proposing that your nephew be the landscaper, you got to go through all of those hoops and approve it properly and do the disclosures and be subject to the petition. Okay, so now we're on to HOAs, which is similar, but a little bit different. This is a new law that's effective October 1, where they're trying to enhance the HOA Act to incorporate more of these disclosures. The HOA Act was kind of lacking and it's somewhat always behind the Condo Act, but due to, I think, the hammock situation, they are trying to incorporate some more disclosure and some more teeth into these type of issues. So here we now have, as October 1, that directors and officers must disclose to the association anything that may reasonably be construed to be a conflict. And there's a rebuttable presumption that these two instances are going to be a conflict. It's where the same thing, the director officer or the relative of the director officer enters into the contract, or one of their companies enters into the contract with the association. Interesting here, there's no mention of this third degree of consanguinity. The statute was just poorly drafted, in my opinion, because it leaves it open. It's like, well, who is a relative for purposes of HOA Act? Is it like immediate family members? Does it go down that whole list like I just read you with these? So again, this is a new law. It's not even effective yet, but I already see a problem because it's uncertain. We don't like uncertainty in these type of laws. If it, somebody was asking me what the advice is here, I'd probably just say use the same standard as the Condo Act. Anybody within this long list of people, probably apply it to the HOA Act too. So this is somewhat similar to the condo requirements where you have to disclose it. It said 14 days before a vote. It doesn't tell you how you disclose it. Do you just like write a letter? Do you post it? Do you send an e-blast? Once again, a little bit uncertain there, but it has to be approved by 2/3 of the other directors present. It also has to, if approved, right, it has to be brought up for a vote at the next membership meeting, same as condo, and is subject to cancellation at that membership meeting. There's nothing regarding the ability to petition for the cancellation in the HOA Act. That is unique to Condo Act. Another new law that is going to be effective October 1 is for developer directors. If you're a developer appointed director, you have to disclose to the association each calendar year that you have a relationship with the developer, that you have to basically announce. I guess it would be at the annual meeting. Once again, it doesn't tell you how you do it, through a letter that they have to keep in the official records that, hey, by the way, I'm associated with, Lennar or whoever is still in control of the community. So the lot owners members understand that there's that distinction and somewhat interested factor there. That's my presumption of why this was enacted, because lot owners didn't realize that some of the developer appointed directors were not just like regular lot owners. The developer directors and officers also have to disclose any other activity that may be reasonably construed to be a conflict of interest, but just their service on the board isn't going to create a conflict in and of itself. So it's really the disclosure aspect and the two disclosures, that I'm a developer director or if I have any other dealings that might be construed as a conflict of interest. That's new as of October 1 of this year. So managers, what about conflict issues? Managers can contract with an association, but it has to be disclosed. This is all about disclosure. So if the manager has a landscaping company, you have to disclose that this is my landscape company and give the association the opportunity to evaluate whether it wants to do that. Or if the manager proposes that the association use a pool service company owned, by the manager and her sister, that should be disclosed too. But it's not necessarily improper. Once again, this is a disclosure issue. Okay, special restrictions for condominium associations. There's a couple special slides regarding condos and a couple special slides regarding HOAs. Here we have a no maintenance or management contract will be valid unless it discloses financial interests in which the developer has with the vendor, or discloses the financial or ownership interest a board member has with this vendor as well. So I keep going on this theme of the developer having a landscape company. This is a condo now. If a board member has this landscape contract, you jump through all those hoops, you signed the contract. Well, the contract in and of itself has to say in the contract that there is this interested factor at play here. So if it doesn't, that's another way to cancel the contract. I think this is what Jeff Solomon from my office asked earlier. Can you contract with an owner? And generally, yeah, but this is the special rule. If 50% or more of the units in a condominium are owned by a certain party, you can contract with them, but it's subject to cancellation by a majority of the non the other owners. So it typically comes up where you have like a bulk owner. The bulk owner owns 50%. The bulk owner is not on the board, but they want to provide landscaping services. Well, that's fine. But if 50% of the non-bulk owner people vote to cancel it, it's done. That's the special rule. Another couple special rules for condominium associations. An association may not hire an attorney who represents the management company. You can't have them representing both parties. This is interesting. It's somewhat obscure. It doesn't come up every day, but a board member, manager, or management company may not purchase a unit at a foreclosure sale resulting from the association's foreclosure of a lien. That's a conflict issue, but I don't think you hear about this every day. A board member or manager or management company can bid at a bank foreclosure sale, just not the association's lien foreclosure sale. That would be improper under the Condominium Act. That's not an HOA law. Another special condominium law, an association and its officers, directors, employees, and agents may not use a debit card issued in the name of the association or billed directly to the association. No debit cards. That was a new rule as of, I don't know, probably 5 or more years ago. So this is, I think a lot of people know about that. All right. Trying to talk quickly now. So another new law, I wanted to put this in the presentation. It doesn't exactly fit the topic here, but since it was new and it's sort of related, I wanted to include this. As of October 1, there was, I keep saying this new date, but there was a bill last year, which was entitled the HOA Bill of Rights. It was House Bill 919. And one of the main points of this was this fraudulent voting activities to, further define what you could be in criminal trouble with in terms of election issues in homeowners associations. So this is particular to HOAs, not condos. We have not seen this in condos, but each of the following acts is a fraudulent voting activity and constitutes a misdemeanor of the first degree, punishable as provided in the criminal statute. So we won't go over all of this, and you'll get this presentation after we're done here and you can go back and read this stuff. But, let's see, preventing a member from voting or preventing a member from voting as they want, changing a ballot envelope, changing a voting certificate, menacing, threatening, or using bribery or other corruption to attempt directly or indirectly to influence, deceive, or deter a member when the member is voting, using or threatening to use force, violence, or intimidation, or any tactic or coercion or to induce or compel a member to vote or refrain from voting. And this is number 5, actually, is the one I thought was somewhat likely to come up in terms of these. I don't see this kind of stuff a lot, but giving or promising directly or indirectly anything of value to another member to basically get them to vote for you. You can't say, I'm going to give you a gift card, or I'm going to, pay for your assessments for the next couple of months if you vote for me. That is now a fraudulent voting activity. It doesn't apply to food served at an election rally. That is specifically carved out, but you can't, try to pay people off to get their votes, essentially. And this is new as of October 1. I don't know what will come of it, if we'll see charges really related to this stuff, but stay tuned for that kind of stuff. Okay, so warnings. What are the warning signs? What do we typically see where could give you, like, raise your eyebrow as to, okay, we have a problem with some of the stuff that Allison just told us about? Excuses, right? Everybody's doing it. It's not a big deal. You know, I'm going to get that free mulch because the prior president did it, and I'm just going to do the same thing. Well, just because everybody else is doing it doesn't mean it's right, right? Lack of clear goals and directions. And this is kind of like internal controls, really, not in those words, but, you know, don't compare what you're doing to just economics. Stuff costs money. You can't just say, we're going to keep your budget down and do everything poorly, or, you know, cut corners, right? So you can't just compare everything to the budget. Sometimes you got to increase your budget to properly operate and to do the right thing. Warning signs: refusing or hesitant to obtain professional advice. You know, I understand legal fees are expensive. I wouldn't want to pay them either. I see the bills, but you have to have professionals that you can rely on to make sure that you are going to be protected. Going back to those first couple slides, if you don't get advice and you just go off on your own, I mean, that's probably not the best thing to do. Similarly, if you get advice from an attorney and you don't like the advice and you go to another attorney and they say the same thing, and then you go to another attorney and, oh, they told us we could do it. You know, that doesn't look so good either. And it's even worse for engineering issues. If you go to an engineer, they tell you something's unsafe. You go to another one, they tell you it's unsafe. And now you're trying to find one that's going to go the way you want. Not a good idea. That's not, you know, reasonable reliance once you know something is an issue. Disinterested in the membership, going back to the slide. You know, once again, you got to act in the best interest of the entire association. You can't make it a me versus them type of thing, that, you know, you want to get what you want and you're going to get it no matter what. That's going to lead you to trouble. Apathy in members. A lot of associations, you know, operate and members are very happy, right? I think most of them do, where you don't have a lot of people coming to board meetings. You don't have many complaints. You don't have many comments. You don't have a lot of uproar. And sometimes that leads to directors thinking that they can just, you know, act unilaterally because nobody's complaining about it. I'm gonna just do whatever I want to do. That's gonna eventually catch up to you, and it's not a good idea. So what are your goals here to be the best in show, or best association, best practices? Have a lot of policies, really, right? You're going to want to have policies and procedures, good internal controls. For example, if you allow an individual director to incur an expense for your association, have a policy concerning what the limit is, that one member can approve $1,000 or less for X, Y, and Z, or that the manager can incur this amount of money without board approval, or, you know, whatever they have to do in the event of an emergency, right? Do bidding, right? We all know that we have to bid for a condo association. You have to get bids when something exceeds 5% of your budget. Or in HOAs, it's 10% of your budget when it exceeds 10% of your budget. But it's not a bad idea to get bids, you know, on other items. And while you really only have to get 2 bids, it's called bids, plural, not 3 bids, unless your documents somehow require you to get more than 2. It really is only 2. But it's a good idea to protect yourself in terms of some claim of mismanagement where you get multiple bids. And going back to these interested transactions, right? If you're going to enter into a contract with a director's company, you better be sure you got a lot of bids there, and the director's company is going to charge you a reasonable amount as compared to the other bids that you got. That is critical, and I did not mention that way back. Require these annual board certification courses. If you're the manager or the secretary, make sure that all of your directors actually have completed the educational course or have signed the certificate and you have them on file. Use licensed and insured contractors. Review your financial statements. A lot of people just, you know, they come across their desk and they don't look at it. Review your monthly and annual financial statements. there's no code of, or there's no legal requirement, for example, to have like a code of ethics or a code of conduct or a conflict of interest policy, or even like job descriptions for your employees. But all of that stuff helps you to establish good internal controls and prevents some comment or qualification in your annual financial statement, where sometimes we see the auditor will have a qualification or a comment, no code of ethics, no code of conduct, and they're not required. So I'm not sure sometimes why they put those in, but it's definitely not a bad idea, especially for larger associations with a lot of stuff going on, to have policies, codes, and whatever you can, and you got to comply with them, obviously. Then the almost last thing is to document everything. I said have these policies, develop your controls, but make sure they're in a written form. Adopt board resolutions providing for these things, a collection policy, that what authorities you've delegated to a committee. Because if you can't connect the dots here, that's a problem. You have to be able to follow the bouncing ball of authority, who's delegated the authority, who made the decision at what meeting, and keep good records of all of this stuff. So, in law, document everything is always very important. Be careful what you put in writing is important too, but that's not what we're talking about right this moment. Lastly, make sure that your governing documents provide for broad authority for indemnification of directors who are sued in their capacity of their service. Sometimes committee members are not specifically noted in, for example, the articles of incorporation where they talk about indemnification. And if you're a committee member and you serve on like the fining committee or the finance committee or the ARB committee, you want to be sure that you're also covered with respect to defense and indemnification, and also in your directors and officers policy. That is the liability policy that will be implicated if you are sued in your capacity as a director, officer, manager, committee member. So it's not a requirement of the law to have this directors and officers policy. It's shocking, but you gotta have it. I would never serve on a board if you did not have directors and officers insurance, because it is implicated, because sometimes things happen and, even when you do everything right, sometimes you're named in some kind of lawsuit, and that's why you want to have that. So I know we're pretty much at the end of this presentation. I'm not sure if Kevin or Courtney or Jeff have any specific questions, or if we have anything from the audience that we want to get into, but I always enjoy presenting, and I want to thank GRS again for having us partner with them today to give this presentation, and I will be happy to come back anytime they would like.
Thank you so much, Allison. That was great.
Did a great job.
I don't think I have any specific questions, but we do have some questions in the chat. So if we could get those answered. Brian had asked, can a board member be reimbursed for travel expenses to board meetings if the board member lives out of state? I would think
I don't think that's appropriate. You can get reimbursement for, things such as buying toilet paper for the clubhouse bathrooms, and for, very special circumstances where, let's just say this director was up north and had to come down for a deposition for the association, like, something really special where like he had to be there on a certain date and it was way outside the norm. Yeah, maybe, but in generally, no, I don't think that would be appropriate. Plus there's Zoom these days. Why would you need that?
Yeah, exactly.
What else do we have?
The next one, Jenny asks, the assistant manager that has been at this property for over 3 years is leaving. She is well liked and the board would like to fund a luncheon for her.
That's nice, right? I appreciate that. It's always nice to be recognized. I don't necessarily have a problem with that. in terms of a conflict of interest issue, but what people always raise here is that it could be an improper common expense. That, you know, we're only allowed to use association funds for certain things. What our documents specify, we're allowed to pay a salary to the assistant manager and maybe give a bonus to the assistant manager. But usually parties and luncheons are usually, depending on the community here, and this is somewhat of a governing document specific issue, are sort of outside the scope of what's a proper common expense. You might want to just take voluntary contributions and use the voluntary contributions to have the luncheon instead, to avoid any, you know, financial mismanagement, not a proper common expense type argument.
Yeah, I'm glad you said that, because Jenny followed up a little bit farther down the line there. She said, is it okay for the board to utilize the association funds for this, even though it is not in the budget? So that was a follow-up to her initial question. So you hit it on the head there.
Yep. Let's see, how can you get bids for property insurance when you're lucky to get one? Well, that's kind of like outside the scope here. Yes, property insurance, difficult market here. If you're in a condo, you know, from before the mid-90s, you're probably going to be with Citizens, you know, no matter what at this point, particularly if you're near the water. But, you know, that's not really part of this in terms of your required bidding. A lot of times, if there's only one provider that you can get, then the bid requirement doesn't come into play.
And I can jump in. I mean, that's a more property management direct question. That's why you have an insurance agent. So as Allison mentioned earlier, there's different professionals you get involved in your association. Your insurance agent for the association would be the best to explain the different options that are out there, because it is challenging and very limited market right now.
Yes, definitely. All right, can a board refuse to allow owners to use the Zoom link if the board is meeting and using Zoom? Well, there's no requirement that an association give owners a Zoom link for a board meeting. We all kind of got used to it during the COVID times, where your board meetings were possibly all Zoom, and then it went to in person with an option for Zoom, but there's no requirement that owners get to attend a board meeting on Zoom. And the board is allowed to use electronic means for the board meeting. So this is kind of one where the board gets to do it and the owners don't, if that's the way the board chooses to go. Yep. Let's see, Marley, would you recommend an association hire an owner as their property manager? Probably not, just because of that potential for the fallout and, you know, other problems. That's just my personal view of it, but is it wrong? No. Could it be helpful? Possibly. You know, they live there, they know the community, they know the quirks, they know the ins and outs, they know the issues. So it kind of is like pros and cons, and you'd have to evaluate that for your association specific needs. Depends, in my opinion, maybe like how large you are and various factors, but I probably, just the potential for problems, I think I would probably personally err on the side of no, but it's not improper. Let's see. What is the percentage required by members to vote on canceling a contract at a membership meeting? So we talked about if the board enters into one of these interested transactions and the director's landscaping company is serving your community, that has to be brought up at a membership meeting, and then a majority of a quorum of the members in attendance can cancel the contract. If there's, you know, if there's no quorum, then there is no meeting and there is no disclosure. So that's kind of like a quirk, right? But it's a majority of those in attendance by person or by proxy. Can a property manager in charge of particular units vote on behalf of the unit owner? No, probably not, unless the property manager is has some kind of ownership or other interest in the unit. But, you know, for a condo election, let's just say the owner has to cast the ballot. If you're voting by proxy for some matter, we'll just stick to condo, the owner has to sign the proxy. So generally, I would say no. Maybe if they got a power of attorney or some other creative type situation, but with very few facts, I would say no. Can managers accept holiday gifts? Well, they didn't say from who, Gina, but I would generally say yes, personal ones with respect to from the association. There could be that common expense type thing. And the statute does say that they're not allowed to get kickbacks. So even managers have to be somewhat, thinking about, is this gift some kind of improper kickback? Am I doing a certification class soon? I don't know. That's a Jeff question.
We have one coming up next week, and I'll go over that after we finish the Q&A, once we go over the evaluation one more time as well. So let's do 2 more questions, because and then we'll turn off the Q&A, and then we'll go over the housekeeping. So pick a couple more.
Okay, a condo president pays cash to some vendors because he says it gets cheaper pricing. Conflict? I mean, that's like a bad policy and a problem with internal controls and documenting expenditures likely. So I would say, on your own personal stuff, do what you want, but you're running a corporation, right? Paying cash is probably not the best thing to do in terms of backing up your financials. I'll have let's see. I think we probably can cut it off there. There's a lot of these long questions, which are hard to get to. But I appreciate all of the kudos that I'm seeing. And I am willing to get emails from you attendees, if you're out there, if you did not get your question answered and you want to keep it very short and not detailed as to your specific association, feel free to email me. And I do try to get back to those who email me if they do in fact keep it short and not too specific. Obviously, I can't be giving legal advice. This is general educational purposes. So I'm happy to do that if you want to email me at hertz@kbrlegal.com.
Well, thank you. Thank you. Before we go over the evaluation, the certificates, and where you can find some of our upcoming events, Courtney, Kevin, anything you'd like to mention to everybody? How can you best be reached if somebody wants to reach you guys as well?
Thank you, Jeff. So I can be reached best by email. My email is C as in my first name, Courtney, and my last name, Buchan, BUCHAN @grsmgt.com. My direct line is also 561-941-4220. I will try to get back to you as soon as possible via email or phone call. I normally always pick up my phone calls and answer my emails in a timely manner. Thank you again so much for providing this course. It's been great. Any of our GRS managers that didn't have a question answered, if you want to direct that question to me, I'm always happy to help answer any questions you guys may have. Kevin, did you have anything that you wanted to add?
I want to say thank you. My contact information is on our website, grsmgt.com. So that makes it easy to write anything down. But thank you to everyone. Allison, Courtney, Jeff, everyone did a great job.
Thank you so much.
Thanks.